What you're about to watch is one of the most surprising DUI hearings you'll ever see. At first, this sounds like an open and shut case. But as the testimony unfolds, the entire courtroom starts questioning whether the arrest should have happened at all. Stay with this one because every answer changes the story.
Your first witness.
Your Honor, Roy Denny on behalf of the Commonwealth, call Officer Goldberg with Jeffersontown Police Department.
All right, and for the record, this is the Commonwealth versus Jeremy Hagan. Officer Goldberg, if you'd raise your right hand, please.
Yes, ma'am.
Do you swear or affirm your testimony today is the truth and the truth and nothing but the truth, so help you God?
Yes, ma'am.
Okay.
Officer Goldberg, would you please state your full name for the record?
It's Daniel Jordan Goldberg.
And where are you employed?
I am currently employed as a patrol officer with the Jeffersontown Police Department.
I draw your attention to January 1st, 2017. Where were you employed then?
I was employed as a patrol officer with the J-Town Police Department.
Okay. And on that date, did you have cause to come in contact with a Jeremy Hagan?
Yes, sir, I did. I did ride a beat with various amounts of intoxication encounters. My DUI experience is limited. However, my charges for alcohol intoxication are extremely high. I did make DUI arrests in the 2nd Division, but I made more arrests for alcohol intoxication. So yes, I have encountered many people under the influence of alcohol.
And going forward, and again drawing your attention back to January 1st, 2017, can you describe exactly what occurred that caused you to come in contact with that? And do you see Mr. Hagan in the courtroom here today?
Yes, he's sitting next to the counsel.
All right, the
Yes.
record reflects.
And can you describe what exactly occurred that caused you to come in contact with him?
Yes, to give times I would need my citation as to recall, so I can go off memory, or I could use my citation to be more accurate.
Well, if he needs to refresh his memory at some point, he can, but you can go ahead and ask him.
Okay.
Okay.
Do you remember the approximate time of day?
No, I don't. I know it was daytime, but I would need a citation for the time, sir.
Okay. Your Honor, may I approach to refresh the memory on the time?
No objection. Okay.
Yes, sir.
And what time was that?
It'd be approximately 16:27 hours or 4:27 p.m., and I do know it was on January 1st, on New Year's Day, 2017.
Okay, and describe to me what exactly occurred on that day that caused you to come in contact with the defendant.
We originally received a dispatch run of an individual walking to his vehicle, getting into a vehicle that appeared intoxicated. The caller came from across the street at the KFC. The KFC is a direct bird's eye view of the rec bar across from Taylorsville Road. So at that point, myself and Officer Carmen arrived right around the same time and encountered the defendant.
And do you have an estimated time from the time that the call came in to the time that you actually arrived at rec bar?
No, sir. All I can tell you is our response times in Jeffersontown are usually extremely quick. We're not as busy as Metro, so it wouldn't be an extended amount of time, but I don't know an exact amount of time. It'd have to look to the CAD. But we did call on scene if you guys want to reference that.
And when you arrived on scene, what did you find?
We found the vehicle first in the description on the run. I'd have to reference it in the citation, but I do know a vehicle description was given. That's how we found the vehicle. We approached it, we parked behind it, and we got the defendant's attention to speak with him to find out what was going on.
Going back to the position of the car, where was it in the parking lot? Was it in a parking space, or do you recall?
To my memory, it was in a parking space, sir.
Okay, do you recall the position in the parking space?
No, sir, I don't.
Okay. And
Well, actually, if I can correct that, I do know we approached it from the rear, and we so it would be, to my recollection, facing the rec bar. The front end of the vehicle would be facing the rec bar.
okay. And you said you pulled in behind the vehicle.
Yes, sir.
You approached it, and can you describe what happened after that?
Yes, sir. So, anytime we encounter anybody, we do a tactical approach, given for safety reasons. So we park behind him and approach from the rear because we didn't know who we were dealing with. We approached, we got his attention. He opened the door, and as soon as the vehicle door opened, I noted I could hear the engine running.
I'm sorry.
I'm sorry,
Okay.
Judge. You could hear the engine running. It was you could hear it on the vehicle. And as soon as the door popped, I got the overwhelming odor, since the windows were up, of alcoholic beverage. That point, from my training, I made contact and spoke with the defendant. I could tell immediately that he had glassy, bloodshot eyes, slurred speech, and I asked to speak with him and to step out of the vehicle at that point. And then I could see that the keys were in the ignition, obviously, because the vehicle was running too. So he stepped out and spoke with us.
Do you recall what gear the car was in?
No, sir. And when I either stop or encounter someone, I'm usually looking at the individual, and as long as there's nobody else in the car, then versus the interior of the vehicle, if that makes sense.
Was the defendant doing anything?
Sir, I don't remember. I wouldn't know.
Okay. Do you recall if he had anything in his hands?
I don't remember. I can tell you he didn't have a weapon, but that's the only thing I'm looking for in his hands. I don't remember anything else that would have been in his hands.
Okay. Do you remember his demeanor? Can you tell us about his demeanor when he exited the vehicle?
Yes. I need to find a better adjective for this, but it was annoyed. I spoke with him, wanting to know why we were there. Once the door opened up, this originally was an encounter. I could smell, obviously, the strong smell of alcoholic beverage, and the vehicle being on, it turned into a stop. It transitioned once I smelled it. He stepped out, and at that point, since the vehicle was on, the keys were in the ignition, it was us requesting to do field sobriety tests, which he originally agreed to, and then didn't say no, but wouldn't do them. Just continued asking, obviously that he was, or continued stating that he wasn't driving.
Okay. Do you recall how many times he stated he was not driving?
Sir, I don't remember. No.
Do you recall any lights on the vehicle as you approached the vehicle?
No, sir.
And just testified you had the request to do a field sobriety test, and what exactly happened after that request? Can you go through that again?
Yes, it wasn't a no. It was a constant state of I wasn't driving. During this, though, the defendant, during his unsteady gait, started to fall over, and myself and Officer Carmen had to physically catch the defendant from falling over. At that point, I know in training from the academy that I'm responsible during field sobriety tests if this gentleman gets hurt. So at that point, based off his manifest his condition under alcohol and his demeanor, we decided he'd be under arrest at that point. We tried placing handcuffs on him. He physically resisted. We told him to stop resisting, and after we overpowered him, we got him in handcuffs, and the incident was over.
Okay. And what was the exact basis of the arrest?
Basis of the arrest for driving under the influence. He was in the driver's seat, the vehicle was on. And the secondary charge was resisting arrest based off his lack of putting his hands behind his back and physically attempting to pull away and then not putting his hands together. His muscles, when you touch somebody to handcuff him, his muscles were extremely tense as if he was lifting weights and pulling his arms apart. We had to physically push them together after several attempts to tell him to stop, so we didn't have to push them together. We could just handcuff him without incident.
Okay. Were you able to handcuff him on your own?
Yes and no. It's a little safer for the defendant if two officers do it, so myself and Officer Carmen pushed his arms together so there wouldn't be any harm to the defendant, because that's our biggest goal, is to get handcuffs on without any incident. So it required myself and Officer Carmen.
Now, we'll focus on primarily right now, based upon your experience and training, as you stated, did you believe the defendant was under the influence of alcohol?
Yes, sir.
Further questions at this time?
No caller, to your recollection, stated that the vehicle has been moved, correct?
Sir, I can't say yes or no on that. I don't know, or I don't remember. I'd have to look at the CAD or listen to the room.
You never saw the vehicle move
No, sir.
at any point.
No, sir.
When you, at some point during the encounter with Mr. Hagan, did you notice that the gear shift was in park? I'll simplify the question.
No, it would be the same answer, and it's just a common practice when I meet anybody, not that this guy's a dangerous individual.
It's a simple question, officer.
Well, then-
Did you or did you not notice?
Well, I'm trying to answer
Objection,
it.
Your Honor.
So-
I think it's
It's a yes or no. I mean,
okay, then, I mean, no.
Okay,
but
that's okay. You don't. You're
sorry.
good. He can continue with this question.
Thank you. After you arrested Mr. Hagan, was the car left there or was it towed?
I don't remember. I'd have to look at that. I need to refer to my citation for some of these questions, so I don't remember.
To be frank, I don't believe this is in your citation, so I don't think it's going to be helpful. So if you don't remember, you don't remember.
No.
After you made contact with Mr. Hagan, did you notice that he had his cell phone in his hands and he was using it?
No, sir. I don't remember what was in his hands.
Do you recall, you stated that he was, you couldn't find a better adjective, but you said that he was annoyed. Do you remember that?
Yes, sir.
He's also made some statements to you, right?
He made a spontaneous utterance in some statements, yes.
I don't need the legal terminology, just he made statements to you, and I think you already testified to a couple of them. He told you that he was not driving, correct?
Correct.
And he said that several times.
More than once.
More than once. Did he? Which cruiser was he placed in after he was placed under arrest? Was it in your cruiser?
I transported him to the jail, so yes. I don't know what vehicle originally, but he was in my cruiser to go to jail.
On the way to the jail, do you remember him continuing to make statements about the fact that he was not driving?
I don't remember that. I remember he made statements, but I don't remember other than one statement what he said.
Do you remember him stating that his bar tab was still open and he was going to go back into reg bar?
Sir, like I said, I only remember one statement because it's in my citation. I don't remember our conversation. It's been a few years.
Do you remember him making a statement to you that his he still had tokens for the arcade at rec bar?
Sir, I don't remember any other statements other than the one made in the citation, sir. It's
Do you recall him smoking a cigarette at the time of your encounter with Mr. Hagan?
I don't remember.
So, if I'm clear, just to clarify the record, all you remember is the fact that he was intoxicated, based on your testimony, correct?
I remember that, yes.
That the vehicle was parked, correct?
Vehicle was parked, correct.
Was never moved, correct?
I can't testify to that. It wasn't moved in my presence, sir.
In your presence. All I'm asking is from your presence,
Okay.
from what you saw, heard, seen, smelled, etc. We're only going over that, officer.
Okay.
You never saw the vehicle move,
No, sir.
and you have, you stated the engine was on, correct?
Correct.
Was the heat turned on? Do you
So-
recall?
I don't remember that, no.
I don't believe I have any other questions.
Your next witness.
Your Honor, call Officer Carmen with Jefferson Police Department, Jefferson Town Police Department.
Is he? Are we okay to release this officer, or do you want him to stay? If he wants to stay,
I'll stay now. It's
okay.
on duty.
All right. Come on.
He's not subject to recall, so if he wishes to leave, I have no objection,
Okay.
Your Honor.
You raise your right hand.
Yes, ma'am.
Do you swear or affirm your testimony today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right. Have a seat, please.
Did you participate in the arrest of a Jeremy Hagan?
Yes, sir.
Okay, do you see him in the courtroom?
Yes, sir.
Okay. And my questions are going to be fairly limited. Testified that you had experience in DUI. What behavior did you notice of the defendant on that date of the arrest on January 1st?
I noticed, as Officer Goldberg previously stated, he had the overwhelming odor of an alcoholic beverage coming from his breath. He had slurred speech, very unsteady on his feet, all which, to my training and experience in numerous DUI arrests and intoxicated persons encounters, was all evidence to me of intoxication level.
And do you recall the position of the gear shift of the vehicle?
I do not remember, I'm sorry.
Do you recall if the defendant had anything in their hands?
I cannot remember. All I can say is the same as Officer Goldberg. I was looking for weapons, and he did not have a weapon in his hand, is all I can testify to.
Okay. And Do you recall the position of the vehicle in relation to the roadway?
To the best of my knowledge, as Officer Goldberg previously stated, it was parked in the parking spot, and where we approached off of Taylorsville Road, the rear of the vehicle would have been closer facing Taylorsville Road, to the best of my knowledge, and the front would have been towards the wreck bar.
Just a few brief questions, Officer. You stated the vehicle was parked in a parking spot, correct?
Yes.
You never saw it move.
No, I did not.
Did you hear when Mr. Hagan was saying that he was not driving the vehicle?
I heard it
Objection,
when...
Your Honor, I think that's outside of the scope of the direct examination.
This is not a trial, Your Honor. The rules of evidence are relaxed. I'm simply asking him another question that he was present, so I think he can answer whether or not it happened or not. He was present at the scene.
The scope of my direct was just the intoxication.
I don't believe that a suppression hearing can be limited to the scope of direct. The rules of evidence are very relaxed in suppression hearings. For trial, I would agree.
All right, I'm going to allow it.
Thank you. So my question to you was, Officer, do you recall Mr. Hagan stating to you, or just stating that he was not driving?
I remember when we were requesting the standard post-sobriety test, because that was the reasoning for, as we were trying to perform them, I remember him stating that.
Do you remember how many times he said it?
I don't remember how many times.
Do you recall him having a cell phone in his hands during the encounter?
As I previously stated, I cannot recall if he had a cell phone. All I can remember is that he did not have a weapon, because that's all I'm looking for when I first come in contact with somebody, is any weapons that can harm me, or my partner, or somebody else.
Do you recall him stating that his bar tab was still open and he was going to go back?
I do not recall him saying that. I can't remember.
Do you recall him stating that he had tokens for the arcade at Rec Bar?
I do not remember, to the best of my knowledge, him ever saying that.
No further questions.
All right. Anything else? All right, thank you for your testimony. We step down. Any other witnesses for the county?
No, Your Honor.
Any witnesses?
No, Your Honor.
Argument?
Yes, Your Honor. I believe that this appears to be a classic 17. I have cited Wells and Armstrong, which are the two general cases dealing with these types of situations, but since then we have also had Crosby come across our Court of Appeals. And in Crosby, Your Honor, I think, if anything, this case is pretty much a copy of what happened in Crosby. Officers in Crosby have arrived upon a vehicle where the engine was running. It was legally parked on the side of the road. The defendant was slumped forward behind the wheel, smoking a cigarette and texting on her phone. So she was awake. Engine on, and she was awake. Those are the first two elements of Wells, which in this case, and in Crosby as well, are clearly not met. She was subjected to field sobriety tests and was subsequently arrested. The officers in that case also testified that they never saw the vehicle move. The vehicle was never removed from the location. There were no other witnesses called to the stand to testify that it was moved. So again, the court initially suppressed all the evidence. There was also a motion, I believe I already alluded to this, to ask the judge, this was Judge Crosby, to dismiss the case, but he said he did not have authority, so he simply suppressed all the evidence because he determined that there was, and the Court of Appeals agreed, that there was insufficient evidence to show that there was, quote, operation and or physical control pursuant to statute. In order for an individual to be arrested for a DUI, let alone convicted, in order to be arrested, the the jurisdictions are split in the United States, and Kentucky is on the side of if the individual is awake, the engine is running, but there is no movement and there is no indication of intent to move the vehicle, which there was none in this case, as the defendant himself stated several times, and both officers testified universally, and it's in the citation, that above stated that he was not driving. So I believe the Commonwealth in no way, shape, or form can provide, they haven't provided any evidence that Mr. Hagen was in operation of his motor vehicle. They provided no testimony to show that the vehicle has been moved by Mr. Hagen. There is no operation, there is no physical control. That is an essential element of the DUI offense, and it is absent in this case. And as a result, I believe that both officers, and I think it was actually Officer Goldberg that placed Mr. Hagen under arrest with the assistance of Officer Carmen, but both officers lacked probable cause. The arrest was unwarranted in this case, and I request that all evidence that has been seized from Mr. Hagen, any statements that he made, any field sobriety tests that he was subjected to, and the breathalyzer refusal that happened later on at the police station, all be suppressed. Again, this is a classic Wells-Armstrong, and this is even more similar to Crosby than any of those previous two cases, because I believe actually both Wells and Armstrong were both sleeping individuals, and Mr. Hagen in this case was awake. So I believe, Your Honor, the Commonwealth has not met its burden, and I request that all evidence be suppressed in this case. Thank you.
That you deny the defendant's motion to suppress the evidence in this case, and the reasons are fairly simple. I want to frame it first that we're here for whether or not there was probable cause for the arrest. This is not a trial, as we discussed in the preliminary procedural issues. The Commonwealth has the burden at trial and has the burden at a suppression hearing, but the burden is much lower at the suppression hearing, is whether or not probable cause exists for an arrest. In this particular case, what we have is an intoxicated person, a phone call from a caller who, the officer testified that they had received an anonymous caller and received a run from dispatch. They went to the vehicle that was described by the caller, found Mr. Hagen there, sitting in the vehicle, keys in the ignition, car running. As soon as the vehicle door opened, an immense odor of alcohol, as the officer testified, was apparent. I don't think any real argument's been made on intoxication, so I don't feel to go into any depth in there other than the officers both testified that he was, in fact, based upon their experience and training, intoxicated. If we look at Wells specifically, we've got the first two factors, which I don't think there's any dispute. He was awake and the vehicle was running, so we have two factors in our favor. Third factor, the location of the vehicle in all circumstances bearing on how the vehicle arrived at that location. Your Honor, there was a caller that testified that the defendant was trying to get into the vehicle. That's the evidence that was presented. So really we are focusing on number 4, which is the intent. Was the intent of the defendant to operate that vehicle? The officer testified that the event was created on 16:20 or 4:20 p.m. on January 1st for the call. The arrival time was at 4:23 to 4:24. 3 to 4 minutes later, the officers arrived and the defendant was in the vehicle, which the caller stated that an intoxicated person was attempting to get into. The time is important because it's such a short period of time, that we can infer that the intent of the defendant was to leave. As the officers approached the vehicle...
Your Honor, I have to object at this point. There was absolutely no evidence presented by the Commonwealth and no testimony of any intent, and I think this is pure speculation, and I would ask that be stricken from the record.
Your Honor...
Yeah, I mean, I don't know that we can speculate to what his intent is.
Well, we have to look at circumstantial evidence. I could not ask the officers to come to a legal conclusion on his intent, but I could ask factual circumstances, which
Well, then you can argue...
And I understand. I'll rephrase.
Okay.
The officers approached the vehicle. They saw the defendant sitting in the driver's seat of the vehicle with the engine running. A short time after the call went out for an intoxicated person attempting to get into the vehicle. They pulled up behind the vehicle. They approached. The officer's testimony was that they didn't see any weapons in his hand, and obviously didn't identify anything else in his hands. They could not recall, but they were unable to recall whether or not there was anything actually happening that the defendant was doing. I think that's important. Okay, there was nothing specific that the defendant was doing that would negate his intent to drive. There was no smoking, texting, or stating that he was at a party. Okay, the officers did not put any evidence on. They did not. There was no testimony to that effect on that day. That very much distinguishes it from Crosby. Your Honor, additionally, and I understand Wells has been well settled, but in my preparation for this hearing, I think that it is worth noting that Wells was decided in 1994. In 1991, the statute was changed to include or be in physical control. So the statute as written is subsequent to the date of Wells, which is the case that we primarily are relying on. I don't believe that there's really been any case that is directly addressed in physical control of the vehicle and what that means. I think we continue to use the Wells test and address operation, but the in physical control, I think, is an issue that is still unresolved. I believe the defendant was in physical control of the vehicle. I think if we look at the Wells test, he also was intended to operate the vehicle. And finally, Your Honor, I think that probably maybe the most telling reason why I think probable cause exists for the arrest of DUI is Wells relied upon People v. Pomeroy. It's a Michigan case from 1994 that specifically, and this was quoted in Wells, that a person may be operating the car although asleep, or that an awake person in the driver's seat may be in such physical control of the vehicle that he's operating it although the car is motionless. I think that's our case here. The defendant was in operation and in such physical control of the vehicle that he is operating it although the car is motionless. And I think the facts favor that. Additionally, Your Honor, the defendant was manifestly intoxicated in a public place, which would, while the defendant was not charged with AI, I do think that probable cause still exists for the arrest. And additionally, he was charged with resisting arrest, which the officers did testify as to what the basis of that was. So I still believe that there is probable cause for the arrest in this case.
Sure.
Thank you. I believe the Commonwealth made, by my count, about 5 points, and I'll tackle one very quickly, each one very quickly, excuse me. I believe intoxication for purposes of operation is irrelevant. So the Commonwealth's argument mentioning the fact that he was intoxicated, although relevant for an AI, and if the case here is that he was intoxicated in public, which I still don't think is merited since he was sitting in his car, but if the Commonwealth believes the case is an AI case, they should amend the charge to an AI charge. The resisting arrest came after they attempted to place handcuffs on him, and I don't believe the defense has any argument at this juncture as to the resisting arrest. We're not here to discuss whether or not the Commonwealth can charge him with resisting arrest, so those two are irrelevant, I believe, for our purposes. The Commonwealth also stated that he was getting into or attempting to get into the vehicle. That is not against the law. You can be extremely intoxicated but still get into a car. As long as you're not driving, you're fine. We have not discussed his intent because we do not have his intent. We have also, the Commonwealth has also mentioned that Wells is a 1986 case, actually. And yes, the law was changed in 1994, but it was reaffirmed both in Armstrong in 2011 and Crosby last year. So it's still good law. It was never changed, and the language of in physical control was mentioned, probably not in Wells, Your Honor, I don't remember the case verbatim, but I'm almost positive it was mentioned in Armstrong and Crosby, respectively. And finally, the allusion to Michigan. There is absolutely no, it's not persuasive, it's not authority in this case, and therefore I don't think it's even relevant at all.
Your Honor, only that the reference to the Michigan case was the exact quote from Wells, so the actual citation is Wells, just noting that they relied heavily on that reasoning in People v. Pomeroy. So I just want to...
Foremost, I want to thank the officers for the job you all do on a daily basis. I know it's a dangerous job that you all do on a daily basis, and you all protect the community at large, and you protect not only people who are charged as defendants, but all of us. So you're just basically making sure that we're all safe out there on the road. So I really just appreciate that. Based upon the totality of the circumstances, while Mr. Hagan was awake and the car was running, it was January 1st, 2017. It's reasonable to believe that the defendant was in the vehicle using his phone. The officers were not able to testify whether or not he had a phone in his possession at the time, but based upon the fact that it was January, the car was legally parked, and I believe there was at least 3 or 4 minutes that the defendant had sat in the car before the officers arrived. So based upon that, I don't believe that probable cause has been established for the driving under the influence charge, but I'm going to find probable cause if I need to. I didn't think that was an issue, the resisting arrest charge, but obviously we all can agree he was manifestly under the influence, whether it was in public or in a car. But I think at this point, for DUI purposes, there's no probable cause to arrest. So officers, I appreciate the work that you all do, but based upon all of that, I'm not going to find probable cause for the DUI.
And just like that, the hearing comes to an end. The judge acknowledged the officer's work, but ultimately ruled that the evidence wasn't enough to support the DUI charge. Cases like this remind us that every detail matters in court, and that's exactly why these hearings are so fascinating. What do you think the judge got right or wrong? Let me know below.